Great. Well, it's good to be here. It's always great to be here with Cooper Square and tenants who are fighting for affordable housing and community in Manhattan. So tonight we're going to be talking about rent overcharge in rent stabilized apartments, and we're going to talk about what legal rent increases look like, how to spot the signs that you may be being overcharged, and then what to do if you suspect that you're being overcharged. So, which will include some of the nuts and bolts of how to make complaints to DHCR. If there's something as we go along that isn't clear, um, go ahead and drop your question in the chat if the device you're on lets you do that. The Cooper Square Committee folks, I'll just ask to keep an eye on the chat since I can't always see it when I'm sharing my screen. And then at the end, we'll have a longer Q&A session for questions that are more elaborate. Let's dive in. Okay, so let's start with how rent goes up legally under rent stabilization. And anyone here who is a rent stabilized tenant or has been one, this should look familiar to you, though maybe you haven't seen all of it in one place before. But the main way that rent goes up in rent stabilization is when a tenant renews their lease. And when they renew their lease every 1 or 2 years, the rent can go up a percentage. The percentage changes every year. And a body called the Rent Guidelines Board, which is it's part of the government, and its members are appointed by the mayor I'm forgetting how many year terms. Some of them are 2 year terms, but I think there might be some others with different terms. They meet every year and they go through a process of deciding what the percentage will be that year. I'm sure there are people on the call tonight who've actually been part of testifying at the public hearings that they held, or being part of the organizing that goes around into every year, trying to keep those rent increases to a point that are manageable for tenants to be able to stay in New York. It varies. If you look at, say, the last 10, 20 years, the percentage increase for a 1 year lease renewal has been between 0 and 4%. It was 0% only twice, including once during the pandemic and once shortly after. And for 2 year increases, it has mostly ranged from 2 to 7%. So there's no guarantees that those are going to be the ranges that things stay in. And in fact, in the housing movement, we're generally pushing for them to be even lower. That process is underway now. The Rent Guidelines Board has met. They've had some hearings, and they're going to be beginning the process of voting on what the increase will be. So that's the main way that rent goes up. It's when you renew your lease. When there's a changeover to a new tenant, so when a new tenant moves in, for a long time, landlords could collect a really big rent increase when they signed the first lease with a new tenant. It was called a vacancy increase. And it could be 16 to 20%. 16% for a 1 year lease, 20% for a 2 year lease. So, among other things, you can see why landlords had really big incentives to make sure there was a lot of turnover. That, however, ended in 2019 when the Housing Stability and Tenant Protection Act was passed, HSTPA. Mostly people call it the rent laws. And that was the result of really years and years of organizing by the housing movement, as well as changes politically in the state so that Democrats had majorities that they could use in both houses of the legislature. So 2019 is when almost every part of housing law in the state changed. And one of those changes is there's no more big vacancy increase. So when the landlord signs a lease with a new tenant, they get the same increase they would get for any lease renewal. So we're talking about the 0 to 7% range. But when, and we're going to talk later about looking at your rent history. So you're still going to see big 16 to 20% increases every time a tenant turns over before 2019. The other two major ways that rent goes up under rent stabilization uh, are when the landlord makes an improvement to an apartment, a physical improvement. And we'll come back to what that is and what it isn't. But they can raise the rent based on a fraction of what they spent on those improvements. And similarly, well, that's called an individual apartment improvement or an IAI. And similarly, an MCI is basically the same thing, but it's for improvements that are building wide. So things like new boilers, new roofs. So there, each of those ways that the rent can go up has a lot going on under the hood, and none of them are simple. And we'll dip a little bit into some of the complications of them, but each of those could be a whole workshop in itself. So we're not going to get a chance to go too deep into those, but we're going to be using those as we talk tonight, as that's the baseline. That's what's legal. And an overcharge is when a landlord is charging rent that doesn't fall into one of these legal increases. So I want to zoom in first on the individual apartment improvements because historically this is where a lot of overcharges begin. And the reason for that, first of all, most of the time, these improvements, if they take place at all, happen while the apartment's vacant between tenants. So there's no witness to what work was done or not done. Second, unlike MCIs, which are the building wide ones, the landlord doesn't have to apply to DHCR. They don't have to get approval. They don't have to prove they did the work. They don't have to prove how much money they spent on it. They just have to tell DHCR, hey, I did this. And so now the rent is $1,000 more. Right? So every year, landlords of rent stabilized apartments, they have to file registrations with DHCR for each apartment saying who lives in that apartment and what is the rent right now. But DHCR is not fact checking those numbers. They just store them, right? So if your landlord tells DHCR that your rent went from $300 a month to, $10,000 a month, DHCR is just going to write that down, right? They're not going to ask questions. Uh, and before 2019, there was no limit to how much a landlord could charge to one of these individual apartment improvements, right? So those things together add up to a wide open door for a landlord to just tell DHCR, oh yeah, in between these two tenants, I spent $50,000 renovating the apartment, and so I get to raise the rent a lot. And so it's not the only, but it is just it's absolutely was the easiest way for landlords to jack up the rent, and it still is. But the rent laws in 2019 did some things that make it a little harder. For one thing, a landlord cannot charge that they can't get rent increases for more than spending of $15,000 in any 15-year period. Short, simpler, non-math version of that is just that no matter how much a landlord spends on a renovation or claims they spent on a renovation, there's now just a cap on how much they can raise the rent based on that. So rather than making it so that DHCR does more fact checking or more record keeping, the legislature chose just to put an absolute limit on how much of a difference in rent these IAIs could be. So, how do we know if we're being overcharged? It's not easy, but the first thing to do if you haven't done it, and every rent stabilized, in fact, every tenant in New York should do this, even or especially if you're not rent stabilized, is order your apartment's rent history from DHCR. Now, I said that every year landlords who own rent stabilized apartments have to file a registration with DHCR. It's the Division of Homes and Community Renewal, or department, I think now, which is the state agency that, among other things, they oversee rent stabilization. So the landlords are filing these registrations every year, which means you can get a report of what was registered every year, going back to 1984, which is when the registration started. And you can order that a number of ways. You can call 311 and they'll connect you with DHCR once you say you want to order rent history. But you can also go to, there's a neat little company. I think we mentioned them in pretty much every one of these workshops because they've developed a tool for just about everything that we are talking about. It's called JustFix, and their website is justfix.nyc. One of the tools they have that's free is an app or a web page that makes it really easy to order your rent history. You just enter basically your address and and they forward that to DHCR and it'll get mailed to you. Um, the other thing you want to have on hand is the Rent Guidelines Board has its own website, and on it they have their history of all the orders they've given, all the decisions they've made over the years. So you can look up any year and see what was the legal rent increase that year. And they actually have a chart that goes back maybe 20 years about. And so it's at that website right there. Cooper Square is going to share these slides after the training, so you don't have to write down all of these website URLs that are going to be on here. You'll get a copy of the slides, and you can just click on that. But the reason you want to have that handy is that's the history of how the rent was supposed to increase. So you want to have that there as your comparison, right? You want to compare your actual rent history to it. So let's take a look at what DHCR rent histories look like. Right? The next few slides are kind of zoomed in views of what they look like. So you can see here is a bunch of columns. It goes in chronological order by year. This particular one is showing a part of the history from 2006 to 2013. If you look across, the different columns are what was the status of the apartment, when was the registration filed, the name of the tenant will be on there. So that's the name of the tenant at the time. So if you move into your apartment recently, the rent history should give you the names of the people who lived there before. And then in the fourth column, the rent, the legal rent. And then next to that says preferential rent. That is if the landlord charged less than they were legally allowed to. Right. So for an example on this rent history, if you look at the line for 2010, you'll see that the legal rent was 1,686, right? That's the maximum the landlord can charge. The landlord reported that they actually only charged $553 that year. Um, impossible to know exactly why, but sometimes landlords would do that as an enticement to get somebody to move into the apartment, or uh, as a settlement in a court case. In any event, uh, and then if you look over on the right, there's a column that is supposed to say why the rent changed. So most of the time it will say lease renewal, but sometimes it will say improvement or MCI, right? And then finally you get the dates for that lease. Now, so those are that's the basic parts of a rent history. Let's take a look at this one. This is from, I'm not going to give the address, but this is from a building where the rent histories are just like a petri dish of fraud. You can look pretty much anywhere, and there's something either fraudulent or just plain weird going on. So let's start with some of the things that pop out here, and these are the kinds of things that you'll be able to see if you look at your rent history. None of these is necessarily proof that something illegal went on, but these are big red flags. So let's look between the years 2006 and 2007, the rent went from $494 to $1,385, right, which is nearly a triple. And there's no reason given, right? The only reason stated there are Section 8, which is not actually something that changes the rent. And probably what happened here, again, DHCR just writes down whatever the landlord sends them. The landlord wrote down Section 8. But a rent increase from 494 to 1385 would have to have a very big explanation. Um, the, the most likely legal explanation, if it's a legitimate increase, would be the landlord did a huge amount of work in that apartment between those two tenancies. Uh, that is extremely unlikely here. First, just when if a landlord had actually done that amount of work, the tenant would be able to look around their apartment and see. Second, if we actually look at this, and if you could see the names of the tenant, you'd see this was in the middle of a tenancy. And so they really wouldn't have been able to do that amount of work while the tenant was living there. And finally, the number 1385 and 0 cents. Anytime you see a nice round number like that, that should get your antenna up, right? Because legal rent increases are always percentages under rent stabilization, which means they always come out to some messy looking number like $494.16, right? It's not impossible for it to happen to come out to a nice round number like 1385 and 0 cents, but it's pretty unlikely. And so when you put that together with this enormous gap between that and the rent from the year before, and the fact that this happened in the middle of someone's tenancy, the most likely explanation is that the landlord just wrote down a new number. That's what they wanted to charge. And they might have done that because the tenant had Section 8 and the landlord figured, I might as well charge the maximum amount that Section 8 will pay, which sounds like a reasonable thing to think, besides the fact that it's illegal. And not only that, but the landlord then treated that as a permanent increase and based all the rest of the increases off of it. So those are some red flags. There are more red flags if, as if we needed them. Even the next rent increase is ridiculously high. It's a 15% increase. And remember, we looked at historic percentages, like what landlords are allowed to increase the rent by when a tenant signs a 2-year lease, and they were, from 2 to 7%. There has never been a year where it was legal to increase the rent by 15%. Then, again, that number again suspiciously has no num, it comes to an even dollar. Then, 2011, 2012, 2013, a 3-year vacancy, uh, while possible, is unlikely, and it's the kind of thing that shouldn't be that hard to fact check because people who lived in the building then will remember. So these, again, it isn't completely impossible for all this to have happened legally, but it's pretty unlikely. And so these are the kinds of red flags you want to look for. Large unexplained increases, suspiciously round numbers, right? Just unlikely facts. Like, I can tell you this building is in a very expensive and sought after neighborhood. Uh, it is very unlikely that a rent stabilized apartment in that neighborhood would go vacant for 3 years. Right? So this is all very suspicious. Let's keep looking. Right? So skipping a bit further ahead in the same rent history, we see some other things here that are red flags. So take a look at the rent change from 2019 to 2020, right? And if you look at the columns over to the right, you'll see that the landlord wrote as the basis for this rent increase, vacancy lease and improvement. The rent more than doubled from 1686 to 4258. And we know that in 2019, the rent laws changed and there were no more big vacancy increases. So the first explanation or reason for the increase given by the landlord is just flat out illegal on its face. There's no longer such a thing as a vacancy increase. The rest that they give there is they claim it's an improvement. Even in the old days, before the rent laws changed, you should be suspicious of a landlord claiming that much of an improvement. We're going to take a look later tonight at how much money a landlord would have had to spend on renovations to get an increase like this. But in this case, it happened after the rent laws change, when there's a cap on how much they can increase based on an improvement, and it is nowhere near. This is nearly a 250% increase, right? So there's just really no way this could have legally happened. I'd also take a look here where if you look under the preferential rent column, and again, preferential rent is when a landlord is saying the legal rent is higher than this. I could charge more, but I'm charging less than I could. And in this case, it would certainly make sense. Like, it's to rent an apartment for $4,500 in 2021 might be more than they could actually get someone to pay. So they might have rented it for less. But you should always be suspicious when you see this long run of preferential rents, because what is often happening there is the landlord's telling the tenant, this is your rent. And on the lease, it just keeps saying, this is your rent. And then the landlord goes and files this completely other, much higher number with DHCR. And the reason they're doing that is at some point down the line, they're hoping to say, all right, well, the preferential rent is over. And now I can take this huge increase. And we'll see later This is really useful for landlords because there's a time limit on how long tenants have to challenge this. And so this is a way for a landlord to get around that because the tenant isn't seeing these numbers. They don't necessarily even know that the landlord is out there telling the HCR the rent is $4,500. So they have nothing to challenge. Uh, Time goes by, and eventually they move out. New tenant moves in. The landlord says, "Oh, your rent is $5,000." Um, so that again, this is just the surface, and this is a landlord who, is kind of very conveniently dumb and put it all out there for us to see. So don't expect your rent history to have as many big glaring red flags as this. Um, but if there have been any large unexplained increases in your rent, you should be able to see them in the rent history. Okay, so let's dig into the math. I think this is going to be the only math tonight. So let's say you look at your rent history and you see, okay, my rent went up, $700 one year, and the landlord says that's because they did improvements or renovations in the apartment. How do I know if that's true? Right, I wasn't around. So the first thing to do is you can work backwards from the amount that the rent went up, and figure out how much the landlord would have had to spend on renovations. And that's because the law gives these ratios, right? So the landlord spends money improving an apartment. They get to raise the monthly rent by either 1/168th of that or 1/180th of that, depending on the size of the building. So in other words, the landlord, if the landlord spends $10,000 making improvements to the apartment and it's a building of 35 units or less, they want to follow the law, they take that $10,000, they divide it by 168. And the result is how much they can add on to the monthly rent. Same thing in bigger buildings, it's just that the number is 180. And if you're looking at your rent history going back before 2019, it used to be that was 140 was the number they divided by, and that was regardless of the number of units in the building. So that's a good number to keep in mind when you're looking back past 2019. So let's take this and apply it to the rent history we just saw. The biggest increase that we saw was what's in the orange box here on the left, $2,572.29. The landlord raised that amount between 2019 and 2020. It happens to be a 24-unit building, so we're using the 168 number. So multiply one by the other, and the amount of money that the landlord would have had to spend renovating that apartment is over $432,000. Now, we're not always going to be presented with numbers that are that blatant, right? We can look at that and simply say that never happened. There is no way that they would spend $430,000 renovating an apartment that if you bought it might cost less than that. So here we can pretty much just stop right there and say this is some fraud happening. In most cases, it's not going to be that blatant. When I first moved to New York City, I moved into an apartment and we got a rent history and we saw evidence. We saw an increase that would have cost the landlord $40,000. The landlord would have had to have spent $40,000 in the apartment. And it was pretty tough to say whether that happened because that can actually happen. And some things like replacing the floor or redoing electrical work or plumbing can actually get that high. So it's not as obvious. So the first thing to do is, look at when that work was supposed to have happened. And if it was recent, one thing you can do is just look around, right? Is there any major elements of the apartment that look new? And sometimes you can stop there because it's obvious that nothing has been replaced for a long time, or it's obvious that the landlord got renovated the apartment right before you moved in. Um, the next thing to do is look at the Department of Buildings website, because if the landlord spent a lot of money on a big project, there's a good chance they were doing the kind of work that requires permits. And if they got permits, then that will be recorded on the DOB website. You'll be able to see them. So if somebody's saying they spent $75,000 in your apartment and there's no permits, that's either fraud or an extremely expensive toilet. On the other hand, if you look at the permits and they've got 5 permits for electrical, plumbing, fire suppression, and a new floor, then that might actually be legit. And there were plenty of landlords who gamed the system within the law, right? Some landlords realized that nobody was checking and that all they had to do was write down whatever number they wanted. Some landlords would say, no, I'm actually going to spend $50,000 in this apartment because I'll be able to raise the rent and I'll make that money back fast. And it's maybe less legally risky. So not all claimed apartment improvements are fraudulent, but just the fact that we're putting it that way, not all of them are fraudulent. There were a lot. This was a loophole in the rent stabilization code that you could drive a 35-unit building through, and it happened all the time. Finally, if you're talking about a supposed renovation that happened somewhat recently, there are going to be people in the building, and some of the people on this call are those people who've been there for a long time, and they actually will know whether the landlord did work in that building. Um, so this is why one of the reasons why it's so important for people to get together and share information, because separately, we're kind of at the mercy of whatever landlords register, but together, we can put our knowledge together and develop a picture of just about everything that's happened in the building. So let's say that you've done this and it looks fishy. What can you do about it? So there's basically two paths, excuse me, that you can follow, right? You can continue paying the rent that the landlord's charging and file a complaint with DHCR. To be complete, I should say you can also bring a lawsuit in Supreme Court, but that is a difficult thing to do, and is the kind of thing that it's going to be very hard to do without a lawyer. So I'm going to concentrate here on the avenues that are available to everybody. So one thing is just keep paying what the landlord is asking and file a DHCR overcharge complaint. And after this, we're going to look more closely at how you do that. So there's pros and cons. The pros are that you're paying the rent that the landlord asks, so you're not risking the landlord taking you to housing court or suing you. Safe, right? Another pro is that, as we'll see later, if you prove overcharge, you have a really good chance that the landlord will have to pay you triple damages back. That means triple what you overpaid. And so if you are able to keep paying the rent, there aren't many investments out there that give you back a triple return. Um, so that's actually a pretty good deal, right? The cons are one, DHCR moves slowly. Rent overcharge complaints can take years. And finally, of course, you have to pay the high rent and go without that money in the meantime. The other thing you can do is uh, tell the landlord you think you're being overcharged and pay what you think the rent should be. If you do that long enough, the landlord will sue you. They'll take you to housing court for non-payment of rent. And the overcharge issue can be litigated in housing court as a defense. The pros of this are it's much faster than DHCR, right? Housing court moves much faster. You can get to a trial, you can get through a case if both sides want to move quickly within a few months. You also, since the landlord will be in court and having to produce evidence, you may be able to get them to hand over their records. You may be able to get discovery, right? So if they're claiming your rent is correct because they did a bunch of work in the apartment 7 years ago, there's a pretty good chance you'll be able to convince the court to order the landlord to hand over whatever records they have. And that's harder to do at DHCR. The cons, I think, are pretty obvious. You're provoking the landlord to bring an eviction case against you in housing court. And no matter how ready you are for that, it's risky. And you have to go to housing court, which is a hellhole of a place that wears you down even when you're winning. If you choose this option, if it's at all possible to set aside the rent difference, in other words, the difference between what the landlord says your rent is and what you're paying, if you are able to set that aside, that is a very valuable thing to do because if worse comes to worse and you lose in housing court, even in the worst case situation where a life event happens and you just miss court and default, you can always avoid eviction by paying the full amount that's sued for. So that's like a kind of like an emergency lever, an emergency button to avoid eviction. That's not always possible because the overcharge, the amount that the landlord's charging, may be more than someone can afford. So, some people in this situation won't really have a choice about what to do. You can only pay as much as you're able to pay. But to the extent that you're facing this choice, these are the two main different strategies to bring this to a head. I didn't mention it, but it is always, almost always worth just, you know, telling the landlord you think you're being overcharged and see what their answer is. Um, there's rarely any value in trying to keep secret from them that you're working on this because uh, you know, eventually, if you're gonna actually fight the overcharge, they're gonna know and they're gonna be involved in it. Um, it's not, if you say to the landlord, I see on my rent history, you say you did some work 7 years ago. Can you show me your evidence? It's pretty unlikely that they're going to show it, but you really have nothing to lose, and sometimes they do. So I would never, don't rule out just asking straight up. The worst they can do is say, I'm not going to show you. Um, okay, so if you suspect you're being overcharged, how do you figure out what your rent should be? Because you can't pay what the rent should be if you don't know what that is. And this gets a little convoluted because the law is pretty convoluted, and the law is pretty convoluted because housing movement and the landlords have been fighting trench warfare over this for 30 years. And now the law has all kinds of little uh, complications where somebody won a little bit one year and somebody else won a little bit the next year. So I'm going to do my best to try to go over this in a way that is simple, um, but it isn't simple. And if you're not getting your head around it, that's normal. And most lawyers don't get their heads around it the first time either. But again, we'll be distributing the slides afterwards, so you'll have a chance to come back to this. So the first thing you do when you're trying to figure out what your rent should be is you want to find what's called the base rent. And basically what that is go back to the last time that the rent was legal, right? Go back before whatever suspicious thing happened. A little more complicated than that, because of various rules in the law. So what you actually do is you start by just going back 6 years. 6 years from today, from the day you're going to file the complaint. You look at what the rent was on that date, which you can find out from the rent history. If that rent isn't suspicious, right? In other words, are any of the suspicious, unexplained rent increases, did they happen before that? Or did they happen after that? If they're all after that, then and you're not looking to challenge what the rent was 6 years ago, then you start with that number. That's your base rent. If there's more suspicious stuff more than 6 years ago, right? The $2,700 increase happened in 2019 or 2012, then you don't use that 6 years ago rent. You go back as far as you need to in time until you find a rent that you have no reason to believe is wrong, right? Until you've gone back before all the things you're going to challenge. And then just to make it more complicated, the Court of Appeals, in interpreting the new law, put a backwards deadline. You can't look back before June 14th, 2015. If anybody is having trouble sleeping at some point, let me know. I will explain my best understanding of why the Court of Appeals did that, and you should be out like a light. But that's basically saying if you find yourself going back to June 2015, when you hit that rent, you just got to stop and take that rent as it is. So whichever one of these bullet points, whichever one of these things happened, you've got a number, a base rent, right? And then you figure out the current rent by working forwards from it. So just recreate each time there was a lease increase. Look at the rent history, lay it alongside the rent guidelines board history, right? And so every year you can say, all right, 2017, the legal increase that year was X percent. And okay, it looks like the landlord did increase the rent by X percent that year. Okay, next year, right? And just go through, and you can basically create like what the rent should be if the landlord had been following the law. And so when you work forwards, you'll get to, okay, this is what my rent should have been if they didn't, include that ridiculous bogus increase in 2021. Right. I guarantee it is easier and more straightforward to do than that probably sounded. It's much easier when you're actually just looking at the piece of paper with the numbers. But if it's something you haven't done before and you're uncertain about it, talk to someone at Cooper Square Committee or talk to a lawyer that's working with the building. We absolutely can help do that. So what happens if you win? If you actually get DHCR or a judge to say you've been overcharged? So first of all, there's a 6-year statute of limitations, which just means you can't get any money back from more than 6 years ago. And that's the same statute of limitations there is on landlords suing for rent. They can't sue for rent from more than 6 years ago. For decades, the statute of limitations for landlords was they could go back 6 years and sue you for rent, but tenants could only raise an overcharge claim going back 4 years, which is one of the most obvious, like, just fixes we've seen. But thankfully, in 2019, with the rent laws, they made the statute of limitations the same. So you're no longer in a position of a landlord saying, I'm suing you for rent from 2020. Tenant says, I think you were overcharging me then. And the court says, oh, I'm sorry, you're not allowed to talk about the rent that you're being sued for. So you can go back 6 years. If you're being overcharged longer than that, unfortunately, you just can't get damages from before that. So first of all, what do you get? You get a return of all the overpayment, right? All the overpayments you made with 9% interest, which is just the number that is automatically charged when somebody wins damages in New York. Now, in order to do that, in addition to having proven the overcharge, you also have to show the payments that you made, right? Because if, for example, I was overcharged for a year, but I never actually paid any rent during that time, then there's nothing for me to get back. So this is where, when you file the overcharge complaint, you've got some more stuff to attach, right? Canceled checks, receipts, the landlord's rent ledger, if they give you one. But it doesn't stop there, because if the overcharge was willful, which we'll talk about what that means, you get triple damages, which lawyers call treble damages because law school is expensive and the only pleasure we get is using words that nobody else uses. So you can get triple damages if the overcharge was willful. And under the law, when DHCR finds there was an overcharge, they have to presume it was willful. And the burden's on the landlord to show that it wasn't. So you don't have to prove that it was willful, right? A landlord has to prove it wasn't, which is fair because it's the landlord who has almost all the evidence and you don't. Willful is a really broad term. So obviously it includes anything that was on purpose. Anything that the landlord did where they knew they were overcharging is willful. You're going to get your treble damages. But also, even if it was accidental, but it was the kind of accident where the landlord should have known better, right? It was the result of them not paying close enough attention, them being careless. That will also be willful. And since 2019, since the rent laws changed, there's actually only a few kinds of overcharges that DHCR or a judge will find were not willful. One of them is if a landlord bought the building at a foreclosure auction and they just have no access to any records from before they bought it, and they were just trying to do their best to estimate what things should be, but they honestly couldn't get the records. That's been found to be non-willful. Where they make a mistake in some area that's really esoteric or unclear in the rent stabilization code, or something. So DHCR changes their interpretations of the rules occasionally, especially when the governor's office changes between parties. So sometimes the landlord might have been actually doing what the DHCR told them to do. And then later DHCR changed its mind and said, you can't do that. That would still be an overcharge. The tenant would have the right to get their money back, but they wouldn't find that that was willful because the landlord was just doing what they were told they were supposed to do. But those are pretty rare circumstances. if you show an overcharge, the odds are that it's going to be willful, especially when we're talking about the landlord fraudulently reporting apartment improvements. Because there's just no way that you accidentally thought that you did $50,000 worth of work in an apartment and you didn't. That's never going to be a mistake. That's on purpose. And most overcharge is on purpose. Right. And the law says that tenants have two ways. So if you won and you get your damages, the tenant can either choose to get it as a one-time payment, landlord, you owe me this much money, write me a check today. Or the tenant can say, give this to me as a rent credit, and I just won't owe any rent for the next year. And it's up to the tenant. The landlord doesn't get to decide. So what does it look like to file a DHCR complaint? Uh, First of all, it's all done on paper or online. There's almost never any kind of part of the process where you have to go somewhere and you're talking to a hearing officer. Nothing happens live. It's all on paper, which is part of the reason it takes such a long time. But it is also part of what makes it accessible because you never have to be able to take off from work and find childcare so you can spend the day in court. So the system is the tenant and the landlord never interact directly in this process. The tenant submits the complaint to DHCR without sending a copy to the landlord. I mean, you can if you want to, but you're not required to. DHCR sends you back a notice that says they got it and they've given you a docket number for your case. Then they forward your complaint to the landlord, right? So it's going to be like this all through the procedure. DHCR is the one in the middle, passing the materials back and forth, right? So DHCR sends the complaint to the landlord and says, all right, give us your information. Um, and it's called a request for additional information, RFAI, just because if you do file a DHR complaint, you're going to see those letters a lot. Landlord sends their response to DHCR, who then sends it to you and says to you, okay, give us some more information. And it goes back and forth until either one side is just like, I have nothing more to submit, or DHCR says, all right, we have enough information to make a decision. Uh, Unfortunately, each of these steps has huge delays. It could be 6 months to get from step one to step two. You would think that when DHCR does step two, they do step three at the same time, since they're literally just mailing copies of different forms in the same case. But there is often a months-long wait between two and three, and so on. So when you submit, your latest information to DHCR, they may not turn around and send it to the landlord for months. And they may be holding the landlord's response that you haven't seen yet that the landlord sent to them last summer. And a lot of this is because DHCR is understaffed. A lot of it is because, uh, it's certainly in the interest of some political lobbies that this not be a fast process and that DHCR not get more funding in the state budget for this part of its work. But that's what the complaint procedure looks like. And this is part of what the forms look like. So you start this off by DHCR has a form. It is on DHCR's website. I didn't put the website here because if you just Google DHCR rent overcharge, it'll take you straight to it. You can print it out, fill it out, and mail it in. but you can also submit it directly online to DHCR, whatever you're more comfortable doing. So this is not the whole form, but this is what the most substantial parts look like. So on this page, you can see you're entering information about your apartment. What kind of apartment? Uh, Information about your rent. Do you have a subsidy? Um, and your history when you moved in, what your current rent is. These are just the basic facts. And then let's look at some more pages. So here's where you're describing what you think is the overcharge, right? Um, where do you think, or where are you seeing a rent increase that you think is illegal? And it gives you a bunch of choices, right? Um, and then there's space for you to just describe any other facts that you think are relevant. They ask a couple other questions, including have you done this in court? Because if you've already gone to court and the judge ruled on it, then DHCR is not gonna change that. Um, and then this is probably this is what takes most of the time, is filling in your own rent history. Uh, Strange thing to do since you have the rent history from DHCR in the first place, but those two parts of DHCR don't talk to each other. And more seriously, DHCR does recognize that like what you actually got billed by your landlord and what you actually paid them might be different from what they have on record. So the top box here is what was your rent, right? What were you charged? And the bottom box is what did you pay, right? So the top box is what DHCR is going to use to figure out if there are illegal increases. And the bottom box is what they're going to use to figure out if there were illegal increases, how much you overpaid. And this is where you have to attach evidence of your payments, right? So for DHCR to say you overpaid in April 2026, they're going to have to see a canceled check or a money order receipt or a receipt from the landlord or some evidence that you paid. So that's not the whole form, but that's basically what you're going to be spending your time doing and what you're going to have to enter. The rest is, your name, your address, contact information. And then I just wanted to include this because this is, I just wanted to zoom in on, they're requiring you to submit evidence, right? And without evidence, they may either just deny your complaint without even sending it to the landlord because you haven't even sort of given enough to like give something to the landlord to respond to, or because they don't know what to do with it because you haven't given them enough information. So this is the kinds of things that you may need to attach. This is a little further down the road, but just if you're looking ahead, if a few years go by and you get your decision from DHCR and either you disagree and you want to appeal or you won, but the landlord's going to appeal, it's a two-step thing. The first level of appeal is inside DHCR. They call it a petition for administrative review or a PAR. And so it's just going up the chain at DHCR. It's going to a deputy commissioner. You've got 35 days to do it, and you can't submit new evidence, right? You're stuck with the record that you made below, unless something just couldn't have been included below because it just happened. So basically what's happening here is the deputy commissioner at DHCR is just looking at the record and seeing if they agree with the reasoning of the person below them, and they may reverse it. Right? The next step after that, right? So whoever doesn't like what happened on the par, then they can go to court. It's called an Article 78. That's what we call any time that you're appealing government agency action to court. It's Article 78. It goes to Supreme Court. You got 60 days after the par decision. And again, you can't add new stuff at that point. You have to be saying, based on what I gave to DHCR, they reached the wrong conclusion. Once you're in court, obviously you can appeal to the appellate court, you can keep going. But that's very far down the line, and the hope is that you'll be enjoying your treble damages long before that happens. Here are all the websites that I've mentioned, as well as a few others that are useful for getting your rent history, to filing DHCR complaints, to checking on DHCR complaints after you've filed them. Don't need to write all of this down. Again, you'll get the slides, and so you can either just click on these or cut and paste them.